All right, well, thanks again for everybody joining us today. And today the topic is related to international planning. And so as we, have this discussion about estate planning and having the right documents in place, a lot of times the question comes up, well, what if I have properties outside of the country? Or what if we're not citizens within the country? Can we still do our estate planning? Or what if, we have a family member who is not here in the country legally? What do we do with them? And there's all kinds of questions that revolve around property outside of the US or property within the US for non-citizens. And so that's what we're going to talk about today. International planning is an important consideration because if you have property, wherever your property is situated, wherever it's actually located, that's the law that's going to govern the property. And so we have to make sure that we're complying with the laws of the location, right, of what we call the situs of the property. And so there's a lot of situations that can come up that become very complicated, and we're going to try to take kind of the easy explanation towards everything, and then as we get through it, then we'll open it up at the end for some question and answer as well. But let me share the whiteboard here. When we talk about international planning, the most common situations that come up that are related to international planning are three different situations. Number one, the situation where you have part citizen family. And there are different tax considerations, there are different planning considerations, and things to consider when we talk about part citizen families. And so we'll cover that as part of the presentation today. The second situation is where we have foreign nationals, and oftentimes they have property within the United States. So foreign nationals with US-based property, right? And then the situation where you have a US resident with property outside of the US. So we'll call that situation international property. So those are the three common scenarios that we come across that relate to international planning, and that's what we're going to talk about today. And let me just start with sharing a story, because the world is becoming a lot more connected, and we have a global society and global economy, and so there's a lot more situations where people have international planning needs. And the problem is that if you don't know the laws of the jurisdiction where your property is, it can cause problems later down the road. So for example, we sat down with a family, and they're here in the United States. They're originally from a Latin American country, and they have property that's actually very valuable in the capital of their home country. And they haven't been there in the last 17 years, but when parents passed away, they left this property to them. And so for the last 12 years, one of the uncles has been living in the property. Well, in this country, the laws state that if somebody lives in a property for more than 10 years and the owner hasn't declared their rights to the property, then it's basically like a homesteading law, right? Whoever lives there for more than 10 years can basically declare that they're the new owner. And that's what this uncle did with the property. So originally it was just a small house, and it was on the outskirts of the capital. But over the last 12 years, the capital has expanded, and now it's, basically near a big business hub, and it's worth 10 times what it used to be worth. But because they didn't exercise their rights, they didn't go through a probate when mom died to transfer title, and so they weren't on title, and they hadn't actually cleared the title and everything, then the uncle was able to actually get the property in his name because he lived there for more than 10 years. And, sometimes we imagine that these sort of issues won't be an issue because, well, we'll take care of it later in the future. Or of course, it was inherited by me, and then I'm going to be able to leave it to my children. But how many of our children, especially if you're an immigrant, or if you have, family here in the United States that have been raised here, that live here, and maybe they only speak English, how many of them know what to do to be able to go back to your home country and be able to transfer that property to them? It becomes very difficult. And the more separated they are from either from the culture or from citizenship in that country, the more difficult it becomes for them to lay claim to the assets that you leave to them. And so these becomes very big problems, right? Because there's a lot of individuals that have valuable assets that are not being considered as part of their overall plan. And so what we want to do is we want to make sure that as you do your planning, you have the right considerations, the right understandings of what your rights are, and also that you're considering the property that may be outside of the United States that also needs to be addressed in your overall estate planning. So the first one that we'll talk about today is the situation where where you may have a member of the family who's not a citizen. And that can be a variety of different situations, because a lot of times we think that citizenship or residency is kind of a polarized sort of state, right? You either are or you aren't, but that's not really how it works, right? So in the United States, there's a system that we use for immigration called the visa system. And there's a whole bunch of different kinds of visas, and every visa has a different purpose. So the purpose for the visa is for entry into the United States. And your visa status determines what rights you have to be able to enter. But once you're in the United States, the visa actually doesn't have any bearing other than the purpose for entry, right? So a lot of individuals who are out of status, who maybe are not here legally in the United States, they actually came in legally under a visa, but they overstayed their visa, right? Overstaying your visa actually is not a crime, but coming in without permission to enter, that is a crime. So at the end of the day, whether you have legal status in the United States or not, there's a whole body of law that we forget about sometimes because we're so focused on immigration law, right? Immigration law is one part of the equation, but there's a whole body of law that's called alienage law. And alienage law is the rights, oh, it's auto-correcting me, is the rights of foreign nationals or aliens within our borders. And so, so alienage law is what determines whether you actually have the ability to enter into contracts, or if you have the right or the ability to create a trust or create a will or create any variety of different investments. It actually falls under alienage law, not immigration law. So what does that mean? Well, it means that nothing can stop you from doing your proper planning. Doesn't matter what status you have. So whether you're a citizen or not a citizen, whether you're legal or not legal, whether you're a resident or not a resident, you can still do your planning. You can still do your estate planning. And in certain circumstances, you can also do financial planning in the United States. So you can actually acquire investments. You can acquire insurance, right? And if they approve you for an investment or for an insurance policy, then they have to honor the contract. So at the time that you contract, then, the parties entering into the contract, in this case, the investment company or the insurance company or whoever it is, if all the information is disclosed up front and they choose to enter into the contract, then the contract is binding. They have to honor it, right? And so it's the same thing with your estate plan. You are the parties to your contract. If you create a will, or if you create a trust, or if you create a power of attorney, those are all important documents, maybe even more important if you're an immigrant within the United States. But those documents you can do no matter what your status is. And the reason is because you're basically just entering into a contract. Also, another little known thing that, may be of consideration is that there's nothing stopping you from setting up a business, from establishing a business, even if you don't have the right to work within the United States. For a lot of people, may be working improperly, overstaying their visa or not having permission to work with their visa. And then if you work with an improper social security number, well, that's a crime. But you can always set up your own company and have your own company and be a business owner. And that, again, falls under your rights under alienage law. So it doesn't matter what status you have. You can always set up your own business and establish your own business and work that way, right? And so just some things to consider. But when it comes to planning, one of the things that we realize is that, sometimes there's mixed families where there's citizens within the family and non-citizens within the family. Sometimes some people within the family are here with proper visa status, and some people are here, they've overstayed a visa or they came in illegally or whatever the case may be. And so there's different planning considerations for different individuals within the family. Again, nothing stops anybody from being able to do their proper documents. So it's even more important if you're out of status or if you have ties outside of the United States to make sure that you have proper legal documents in place. Because if you were to leave the United States, we've heard lots of stories about people who have houses and they abandon those houses when they leave the United States, and then it gets foreclosed on and you lose all the value that you paid into, right? There's no need to do that. So the basic documents in your estate planning would be, number one, a financial power of attorney. Your power of attorney is a document that allows for somebody to step into your shoes and to be able to make decisions on your behalf. So basically, while you're able to, if you're, healthy and you're conscious and you're able to make decisions for yourself, you can manage all those things. But what if you're stuck outside the country, right? Last year, when COVID was starting, we had a client of ours that was going on a cruise, and their cruise was leaving from Singapore, but they had a layover in Hong Kong, right? And this was after COVID had already started in China. And so because he had a layover in Hong Kong, they wouldn't let him get on the cruise ship. And so he had to return to the United States. One day after returning to the US, one day later, there was a businessman that went to Singapore, right? Because that's where the cruise ship was leaving from. And COVID began in Singapore because this man basically brought it there. And so if my client would have been there one day later, they wouldn't have let him return to the US. He would have had to quarantine there. So he would have been stuck outside of the US. And he's a businessman. He was in the middle of selling his business. He also has employees. Somebody has to make payroll. Somebody has to work with vendors. Somebody has to, manage different accounts and all those things. And if you're stuck outside the country, sometimes that's difficult to do, right? Your power of attorney is what empowers somebody to do all those things for you. So we can activate a power of attorney in the case of incapacity, but we can also create a power of attorney that becomes active if you need it, if you're stuck outside of the country, or if you're traveling, or in the case of deportation, or in the case of incarceration, right? And so we can have powers of attorney that address those risks. The next thing is you want to have proper healthcare documents. So whether it's a healthcare power of attorney, or whether it's a healthcare directive, or whether it's a living will, and every state calls these documents different names, but basically it's a document that will allow somebody to make medical decisions on your behalf. Now, this is important for you to have if you're traveling, because if you're outside of the country, most countries will recognize your medical directives or your healthcare powers of attorney in the medical systems. But you need to have a way for them to be able to get a hold of those documents, right? And so one of the things that we do with our custom plans, a lot of times we actually have papers that are, they're indestructible. So they're not going to crumple up if you put them into your luggage when you travel, and they're not going to get destroyed if you drip, water on them or drip your coffee on them. And so they're good for traveling because they're going to still be, be able to be used in those sort of situations. But then if you come across a healthcare need and you're not in the US because you're traveling abroad or something like that, it's important to have those documents, because you may not be able to make decisions on behalf of each other without those documents. Here in the US, it's difficult if there's liability on the line. A lot of times the healthcare, institutions and whatnot will not allow you to make decisions on behalf of your spouse, even if there's risks, if there's liability. But outside of that, it's somewhat, easy to be able to make those decisions unless it's kind of a crisis situation and so on and so forth. But if you're outside of the country, imagine working with a different healthcare system, and they may or may not have the same laws that allow for those decisions. And a lot of countries are afraid of liability when it comes to foreigners, right? Because we're used to a different, type of medical system. And so if they do something wrong, then they may be afraid of the liability that could come to them. So it's important to have these documents in place and that you keep a copy in case you travel, right? Another thing that's very important, and especially for anybody who's at risk of leaving the United States, either voluntarily or involuntarily, right? Or if you're at the risk of deportation, it's important to make sure that you have a guardian nominated for your minor children. Because if you don't choose who would be the guardian for your kids, right, then the state has a plan for you. And the state says that any interested party can nominate themselves to be the guardian for your children. And there may be some interested parties that you don't want to raise your kids, right? Does that make sense? And so if you don't have that in writing, then you won't have a say if something happens to you. But the same thing happens when you're incarcerated or if you're in the process of having to leave the country. So we've heard horror stories, and you've seen them on the news, of people who end up going through a deportation process or being incarcerated, and then the children have to go into the foster care system, right? And while they're in the foster care system, sometimes they're not reunited. There was a case just not too long ago, a news report about 667 children that they're unable to find the families to reunite them. Imagine that, right? And it's because they ended up going into the foster care system while their parents were were exiting from the US, right? Were being deported, and they couldn't reunite them because they couldn't find them again to be able to reunite them. So the rule of thumb is always to stay together, right? Because that way you're not going to have to look for each other later. But the problem is, especially right now during COVID, is that when people are incarcerated, they give them the option. They say, look, do you want to stay with your children, but it may be unsafe, it may be unhealthy? Or do you want them to go somewhere safe? And then you have to sign this waiver saying that it's okay if you're not reunited, it's okay for them to go into the foster care system and so on. That's what's happening nowadays, right? And so we have an alternative to that, which is you can nominate the guardian on even just a temporary basis to make sure that they can step in and take care of the kids so that they don't have to go into the foster care system. And this is the case just for incarceration in general, right? Because if you go to jail, it's the same issue. We've had this come up with clients where they get there's some criminal charge against them. They go into jail. Their children, right? There's nobody to take care of them, and they're gonna have to go to the foster care system, right? So if you have a grandparent, a parent, a sister, a brother, a family friend, somebody who can take care of them in the meantime, we can nominate that person to be a guardian and to step in that crisis situation, and then they can take care of your kids, and they're authorized to be able to make decisions and to be able to handle things with the school and everything else until you can come back or until you can request for them to be able to travel and be there where you are, right? And so it's important to have these documents, and especially because even if you were to leave your kids with somebody that you trust and you don't have a document that's a temporary document, the first thing that the school requires is for whoever the guardian is going to be, for them to go to the court and get a guardianship or conservatorship to get the rights to be able to make decisions on behalf of the children. Well, when they do that, the most common thing for the court to do is that the court will actually terminate your parental rights when they grant the guardianship to whoever is being requested to be the guardian. So if you're still alive, but you're in another country, right, then you say, okay, well, I want my kids to stay with my mom, but eventually I want them to come live with me, right? And then mom decides that she wants to keep them with her, and a couple of years later you say, hey, okay, I'm ready for the kids to come, and she refuses. Well, they terminated your parental rights. You don't have any rights anymore. She has all the rights. And so it's important to have this nomination of guardian, but it's also important for it to be temporary so that you don't lose your parental rights over the children, right? And so these are some of the things that we help part citizen families to have in place, because there's additional risks that they may be exposed to. The other risk that you may be exposed to is potential taxes. The taxes may be different whether you're a citizen or you're not a citizen of the United States. And so, especially for foreign nationals, right, what happens is that there's two systems when it comes to transfer taxes within the US. So if you are a citizen, or if you're considered a resident taxpayer, then there's one system, one set of rules for transfer taxes, which means gift taxes and estate taxes. If you are a non-citizen or a non-resident alien taxpayer, then there's a different set of rules. Sorry, I can't spell, guys. So, as a citizen, no matter where you die, where you pass away, for estate tax purposes and gift tax purposes, you're going to be considered a resident taxpayer. But if you're not a citizen, you have to meet what's called the substantial presence test within the United States. So what does that mean? It basically means that you have to be within the US for a continuous period of time, at least a certain number of days, but basically at least a third of the year continually, or more than half the year if it's not continuous, right? Then you're considered a resident taxpayer, as long as you die inside of the United States. But if you die outside of the US, you're treated as a non-resident alien taxpayer, even if you have a green card, even if you're a permanent resident. The residency status, based on your visa, based on your immigration status, doesn't determine that. This is purely based on the IRS code, right? So you have to meet the substantial presence test, or you have to be a citizen in order to be treated as a resident taxpayer. And if you're not a citizen, you happen to die outside of the US, you'll be treated as a non-resident alien taxpayer. So what's the difference? Well, the difference is that a citizen right now has $11.25 million of exemption amount for estate taxes and gift taxes for your lifetime, right, per individual. And they're looking at changing that. It may go down to about 3 million. It depends on what happens over the next few months. But if you're a non-resident alien taxpayer, you only have $60,000 of estate tax exemption. So if you have a $1 million estate and you're a citizen or a resident taxpayer, then there's not going to be any estate tax when you die. But if you're a non-resident alien taxpayer, everything above 60,000, right? So 940,000 is going to be taxed, and the estate tax rates cap out at 48%. So it can be very expensive, right? And those taxes need to be paid immediately. They don't give you any delay, right? It's within 6 months of the death that those have to be paid. And so that can cause a lot of problems for an estate. It may also stop assets that you have that need to be liquidated from accumulating value, and so on and so forth. And so it can be a bad situation to have to liquidate assets to pay for those taxes. If you are a citizen or a resident taxpayer, everything that's included in your estate includes all of your assets, all of your investments, and it also includes the death benefits on life insurance. Even though those death benefits are not taxed for income tax purposes, they're counted for estate tax purposes. But if you're a non-resident alien taxpayer, your death benefits of life insurance and everything in life insurance is completely exempt. So it's not counted, right, as part of that total. So, what we do is this balancing act where we have to see, okay, are you going to be a resident taxpayer when you die, or are you going to be a non-resident taxpayer when you die? And we try to work around that to make sure that we're minimizing the estate tax burden. And then there's also different gifting limits. If you're a citizen or a resident taxpayer, you can gift up to $15,000 per person per year without any gift tax consequences. And between spouses, you can gift any amount. If you're a non-resident alien taxpayer, you can gift up to $100,000 per person per year, including to your spouse, without any gift tax consequences. So again, that's something that we need to plan around if we're trying to shift values, right? And one of the ways that we get around these issues is by using, especially with part citizen families, by using what's called a qualified domestic trust. The qualified domestic trust between spouses will delay the need to pay any estate taxes until the second spouse dies, regardless of what your status is. And if you happen to be a citizen by the time that you pass away, or you pass away as a resident taxpayer, then you have more exemption and you don't have to worry about it as much. But you know, there's a lot of value in avoiding the tax up front, right? And then we can also use this sort of structure to situs property in the US. So for example, if you're a foreign national, we had a client of ours that was in the United States for a long time. She lived here for quite a while. She was a permanent resident, and then she was returning to her home country of Japan. But she decided that she didn't want to keep her residency in the US because she wasn't going to return. She didn't have a need for it. When she returns to Japan, one of the worries that she has was she has investments in the US. Japan taxes on worldwide assets for estate taxes. The US also taxes on worldwide assets for estate taxes. But when you're a foreign national, the US will only tax on your US situs property, so the property in the US. But Japan was going to tax on all her property. So one of the things we did was, you know, we have the US over here, right? And she has her house. We put the house inside of an irrevocable trust to situs it in the US. So now it's US property owned by a US entity. It's not part of her estate. So even though Japan may want to tax on the property, they cannot because she doesn't own it anymore. It's sited in the US. So that's some of the planning that we'll do, is planning around, you know, foreign estate taxes and also planning around US based estate taxes. And if you have property outside of the United States, this is the third scenario. If you have property outside of the United States, but you're in the US, then it's important to make sure that that property is subject to the laws of wherever it's located. So we need to have a plan that can address international property. So for example, if you have a house in the Philippines, then the law of the Philippines is going to govern that house. And people will ask a lot of times, okay, can I put my house in the Philippines in my US trust? So if you do an estate plan and you set up a trust, that's a really good mechanism to be able to avoid the court system and avoid probate and avoid, you know, the delays and the problems that can happen when you pass away in the US. But not every country will recognize a US-based trust. Some countries recognize it for the purpose of holding assets that are mobile assets, that are intangible assets like bank accounts, money, business interests. But if you have a fixed asset that is subject to the laws of the location where it is. So if you have real estate is going to be subject to the laws of the location where it is. Some countries will allow you to then put that property into a US-based trust. Other countries will not allow you to do that. And so if you have property in the Philippines, for example, you need to have a Filipino will, because that is going to govern the distribution, the transfer of that property. Whereas the US-based plan can govern the transfer of your US property. But it's also important to make sure that those two plans coordinate, because if you have documents in the US and those documents say that it revokes all the other documents that you have, and you have documents in another country, then one of the plans is going to revoke the other plan. So the two plans need to know about each other. right? They need to address that issue, because you can't, have documents that interfere with each other. And so what we do when we do planning is we do an international certification. There's a UNIDROIT treaty that has, I think it's 36 signatory states, and it's recognized as the method to be able to set up a will that's recognized internationally. So we can certify your will to be an international will. The other thing that we do is in the will, we can specify, okay, for US property, we're going to treat it like this. Maybe you have a trust. We want any property not in the trust to go into the trust. That's called a plural will. But then you have property in another country. So we had a client of ours, for example, that has property in Egypt. And we said, okay, for the property in Egypt, we want it transferred like this. Instead of going to my US trust, I want it to go to my children, right? And then it's certified as an international will. So it specifically specifies what will happen with the property in different locations. But the other thing is that it also says, if I have a document in another country, that document is going to govern my estate and the transfer of my assets. That way it doesn't invalidate the plan that you have internationally. And so if you do have property in multiple countries, it's important to make sure that we're complying with the law of each of those countries. And if you haven't met with local counsel, then it's important to meet with somebody who's aware and familiar with international law so that they can assist you with that type of planning. And the last thing that I'll share with everybody is, if you happen to leave property in another country, or you have a loved one that leaves property in another country and they didn't have a plan, then that doesn't mean that it's lost. We've done probates in 13 countries. So we can handle the court process, and we can facilitate working with local counsel to make sure that the property can then transfer title and be able to pass without problems, even if there wasn't a plan, right? And so we've handled, for example, a probate in Italy, where there was a family that had substantial assets that were left behind. Mom had a will in Italy, but it was never probated. And they needed to make sure that they were actually transferring the title so that they could have access to those assets. We assisted them through the probate process to be able to transfer those assets according to Italian law in an Italian probate. And went through the entire process of making sure that everything could transfer without any problems. So that's a little bit about international planning. And if you have any questions, because you were invited to this presentation by one of the trusted advisors that we work with, then your consultation is complimentary. There's no cost. So we can sit down, we can look at your specific needs, answer your specific questions, and give you an idea of what you may need for your plan. And sometimes it doesn't mean that your entire plan is more complicated. Sometimes it just means that you need a simple plan plus some additional documents. And so we can go through that and those questions with you. If you have questions, feel free to reach out to us, and we're happy to help.